stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome to Administrative Static. Mark Chenoweth and John Vecchione with you as always. And today, John, we're delighted to have join us one of our senior litigation counsel colleagues here at NCLA, Russ Ryan. Russ, welcome back to Administrative Static.
Thank you. Thanks for having me again.
Well, we're glad to have you. I think we're going to cover a couple topics with you this morning, but the one that we wanted to start with has to do with a complaint that you filed earlier this month against the PCAOB, the Public Company Accounting Oversight Board. And before anyone falls asleep, maybe we should start calling it peekaboo, because that gets people's attention just right there. That's how you pronounce that acronym in inside the Beltway anyway. But tell us about this complaint that you filed in the Northern District of Texas, and why anybody should care about the PCAOB. What's going on with their administrative adjudication processes and prosecutorial processes?
Yeah, I'm really excited about this case. The PCAOB was created by Congress in 2002 as part of Sarbanes-Oxley, and the whole purpose was...
This is the post-Enron law.
Correct, which was passed, how shall we say, speedily. But the whole purpose
Helter-skelter even, you might say.
That's my recollection. The whole purpose was to create a new type of regulator that could be as far away from political accountability as imaginable. So it was formed as a private nonprofit corporation. Congress specifically said it is not part of the government. The SEC commissioners appoint the 5 board members, so there's no presidential involvement in their appointment. But what they do is essentially prosecute accountants and accounting firms for violations of their own rules or the securities laws, and thereby they're clearly exercising fairly draconian executive power, not much different than the way the SEC did before Sarbanes-Oxley and still does. But ironically, the board can impose penalties far exceeding anything the SEC can. And for that matter, penalties that exceed a lot of criminal cases. And
there's no supervision by any government official who is appointed by the president or directly accountable to the president?
Yeah, no real-time enforcement of the investigative and disciplinary process. By contrast, the SEC does provide a key gatekeeper function when the board adopts rules. None of their rules can become effective or bind a single person unless and until the SEC approves that rule through public rulemaking.
So there's some supervision on the rulemaking side, but less so on the enforcement or adjudication side.
Right. So that's the crux of the distinction that this case is based on, I think, that when the board investigates accountants and later disciplines them, the SEC is not involved at all. It's done by basically private citizens who are employed by the board.
But there's a jury trial, right?
Of course.
No jury.
You're being facetious, I'm sure.
Yeah. Due process of law? Not. Is there due process of law?
No, there's
impartial adjudicator. Surely we have an impartial adjudicator.
Yeah, I'm sure you've talked before about the due process and fairness deficiencies of agency adjudication in general, but
sure.
The PCAOB adjudication system makes the SEC in-house courts look like the model of due process.
Yeah, PCAOB takes the cake from what I've seen.
Yeah,
and this all happens in secret too.
It does, and that's part of Sarbanes-Oxley too. Now, to be fair, that was a concession made to the accounting profession, which of course does not want the public to know that they're being investigated, or
because they might be found not guilty, right?
Right.
So
and it's save them from reputational harm. The cases do become public if they result in a final settlement or a board decision that gets appealed to the SEC. But when the case is final or gets the SEC, typically it does become public. But before then, unlike agency cases, which are, complaint is public, the decision is public. We don't know, for example, if there have been any PCAOB targets who successfully defended themselves along the way before they had to appeal to the SEC. Those decisions are hidden from public view, which is not only a First Amendment concern, but if you're defending an accountant in one of these secret proceedings,
you don't have access to the precedent.
It deprives you, exactly.
Yeah.
Only the prosecutors do, though, and so does the hearing officer.
Yeah.
So it's that's just one of the things we've also included.
Sounds one-sided.
Objections to the funding of the PCAOB.
Mm-hmm.
It's not funded through appropriation from Congress. In fact, Congress has little or nothing to do with how much money their budget has or how they spend it. Basically, what they do is Sarbanes-Oxley authorized them to what I call impose taxes on public companies and broker-dealers. They use this euphemism called accounting support fee. But it's, in effect, the board decides how much money they want, and then they decide what taxes they have to impose to get that money.
But your lawsuit isn't against, is not within the PCAOB. You've sued the PCAOB in federal district court. So what's that all about?
Correct. Yes. Basically, our argument is our client should not need to go through this clearly unconstitutional machinery, which takes typically, if he were to litigate the whole case, appeal it to the SEC, and then appeal it to a court, it could take 5 or 6 years. And again, it would, for the most of that time, it would be secret. One interesting thing about the complaint is we've sued under a pseudonym of John Doe because we think it wouldn't be fair to require him to identify himself when Sarbanes-Oxley says his identity should be protected unless and until the case is, the proceeding is over and it results in a sanction or he appeals it to the SEC. So,
and so, what are you arguing in this case? You're taking issue with this appropriations clause violation, the lack of a jury trial, and just the sort of systematic bias that's inherent in these adjudications?
That's most of it, and we're also objecting to the notion that that private citizens can constitutionally be empowered to wield substantial executive power without meaningful meaningful real-time supervision by at least a principal officer of the U.S. government. The fact that the only time the SEC gets involved in these cases is the very rare case where someone perseveres through the entire PCAOB process and then appeals to the SEC. The SEC basically plays the role of appellate court. But by then, all the constitutional damage is done and the SEC really can't do much about it other than overrule the PCAOB's merits decision.
Well, and you're not the first one to notice how highly unusual the PCAOB is in all these things. In fact, you point out that the Supreme Court has called it an unprecedented extra-constitutional stew, or at least one justice has deemed it.
In fairness, that
way.
was just now Justice Kavanaugh when he was on the DC circuit.
Okay. All right. Well, hopefully he has not changed his views.
But yeah, this is sort of the next step in the Free Enterprise Fund case, which dealt only with the appointments and removal of the PCAOB, the latter of which the court found unconstitutional and essentially fixed by blue penciling the second level of removal protection. But the court did not address the issues that we're raising here, and I think it's past time for
20 years. You think is enough?
Well, the problem with this is normally the PCAOB and the SEC would say, "Oh no, you got to wait. You got to go through the whole process, the whole gauntlet. It may take years, so be it, and then you can get your normal appellate review." But that's just not practical. There's only 2 litigants in the first 20 years of the PCAOB's existence that made it all the way to a federal court that way.
Wow.
Out of 400 enforcement targets that have been punished already. So what's that? I think that's less than 2%. It's
less than 1%, 2 out of 400. Yeah, that's like a 0.5%, I think. Yeah.
It's just not realistic to expect someone to persevere that long. These are expensive to defend. And generally speaking, once you get certainly charged, sometimes even just investigated by the PCAOB, you need to tell your employer about it, or a prospective employer. I think people in fairness think they need to do that. And that's the end of your career.
Yeah. Well, and that's the end of the time we have to talk about that today. But thank you, Russ, for being with us, and good luck in John Doe v. PCAOB. We'll be back with more with Russ right after this.
Welcome back to Administrative Static, and we're still here with Russ Ryan, and we have an issue that's occurred that isn't a case or anything, but it kind of shows how the administrative state works to bait and switch and basically just interfere with people's plans for no ascertainable reason. So, Russ, tell us about the predict markets. What are they, and why are they in trouble?
PredictIt. So you're right. We don't have a case here right now. There is a pending case. It's in the Fifth Circuit right now. And basically what happened is this is a market that was developed to allow traders to invest in contracts that essentially predict the outcome of future elections and other significant political events. So in 2014, the organizers of this market created a nonprofit and sought permission from the CFTC, Commodities Futures Trading Commission, to operate the market.
And they would control, they have jurisdiction over, this is a commodity, it's a commodity or it's the futures trading part of it, I guess.
Yeah, I think the market would not, the PredictIt market probably wouldn't admit it, but there's at least a likelihood that the CFTC would certainly say that these are something like swap contracts, and so they fall within CFTC.
What's a swap contract? Okay,
You're
getting a bad question.
You're getting a little beyond my
expertise.
Here's
the point of it is Brexit's coming, right? So I want to vote on whether Brexit passes or not, and I put some money down saying Brexit will pass 55%, right, or something like this. So you do it like a sports betting thing.
It's sort of a binary type of contract.
Okay.
So the market, for example, has something Brexit will pass
by a date certain.
by a date certain, and a trader can buy either yes or no, basically. And the price of the contract at any given time is based on supply and demand, like who's on either side.
Fluctuates.
Right. And when the event comes to fruition, if your contract is correct in predicting it, you get $1. And if you're incorrect, you get nothing. So the value of these contracts on either side will fluctuate. For example, if the likelihood is, if the consensus is 60% likely, then in order to buy that side contract, you'd have to pay 60 cents a contract.
And you said this was set up as a nonprofit. And what was the point of this? Was a research?
Yeah, I guess this type of information, just tracking how people are when they really have skin in the game, although it's not much,
Right.
How they actually predict, it's apparently of some value to political scientists, polling experts, gaming theory experts, and others as an academic.
Right. And so, and these are apparently small sums. You can't bet your shirt or something like that.
Yeah, there's the maximum you can put on any contract is $850. And they also limit the number of people who can participate in any given they call them markets, predictive market, which is 5,000. Only 5,000 people can.
So this doesn't see. So what happened?
So they built this market. They spent somewhere between $5 and $10 million building it. They've got
and they checked with the CFTC before they did that.
Yeah, this was in 2014. They went to the CFTC. They said, if we operate this market in this manner, A, B, C, D, please assure us that you won't refer us for enforcement action for not registering. So that's a staff level request.
And what's registering? Tell the audience what registering is. Why do you have to register?
You would register as some kind of exchange with the CFTC because you're the one that's, the intermediary with these contracts and running it. So this is a no action type of letter, just like other agencies do. Staff at the CFTC issued a letter saying, if you do it this way, the way you've promised to do it, we will not take it, we will not refer it for enforcement. So they operate this market for I guess it's about 8 years now. And last summer, I guess it's the same CFTC staffer who'd signed the 2014 letter issued a second letter that said, well, we don't think you're operating it the way you promised. And so we're withdrawing our 2014 letter saying you could do this. And by the way, even if some of your contracts are being operated in the way you promised, you got to shut those down too. And you better do it by February 15th at midnight or something like that.
So how much time did they give them?
It looks like somewhere around 5-6 months.
But the problem is that the contracts post
right, exactly.
Right,
well, that's what I'm getting at here. How do you
biggest
you've
market,
got to breach your contract and you're in huge trouble.
Yeah, the biggest markets are undoubtedly who's going to be the presidential nominees of the respective parties and who's going to win the 2024 U.S. presidential election. Obviously, those contracts will not spot, the event doesn't take place for a few years. So if they're required to shut this thing down on February 15th, they're going to have to unwind all these contracts. I don't think there's any precedent for how they would actually do that. Would they basically pay people based on what the percentages, what the price is that day? Or do you just give everybody their money back, like a rescission or something like that?
I think traditionally Tony came around, right, and said you have failed in your bookie, in being the bookie.
So in terms of the litigation, PredictIt and some people associated with sued the CFTC in the Western District of Texas, I think late last summer, asked for a preliminary injunction. And for whatever reason, the district court still has not ruled on it. So in December or January, they just leapfrogged to the Fifth Circuit and asked for an injunction pending appeal, or in the alternative mandamus. And the Fifth Circuit a week or so ago denied a motion to dismiss the appeal that was filed by the CFTC. And I'm not familiar with this term, maybe you appellate lawyers are, carried with the case the motion for an injunction and the alternative motion for mandamus, and set it down for expedited briefing. I think PredictIt's brief is due today, I think. Might have even been yesterday. I haven't checked. Government's brief is due next week, and the oral argument is scheduled for February 8th.
Got it. And so presumably the Fifth Circuit is preserving its ability to stop this before February 15th.
Correct. Yeah, that's the reasonable inference from the schedule that was set.
And does this happen a lot? I mean, what's going on here that they allow it to happen? And then there's two things that strike me. The one is, does the law say these aren't allowed? I mean, if I go to read the law now, does it say this isn't allowed?
With the market itself?
Yeah.
Not that it's not allowed. I think the CFT would argue that it's not allowed unless and until you register with the CFTC or get an official, what they call an exemption from the CFTC commissioners.
Okay.
So,
and that takes time and money, I take it?
Ordinarily, that takes a lot more money than a no action letter. And if you do register, that brings with it all the burdens of being a registered entity.
Okay.
I haven't tried to figure out why they did it. They went the no action route, but that's normally the way,
right? The
cheapest and most efficient way to get permission to do something that's arguably they otherwise wouldn't be able to do.
Right. You think it's fine. And then you go to them and say, look, we think this is fine. This is what we're going to do. We're going to get in trouble.
Yeah.
And so they make up their minds at the agency. Well, we're not going to get you in trouble now. And then they change their minds 8 years later. The law hasn't changed, right?
No.
Okay. So Congress hasn't done anything. All these people have invested these millions of dollars. They've gotten people outside their group to come and bet on these markets. Maybe they have political science looking at this information, and maybe somebody's got their thesis already for like one of these contracts. It's going to come down afterwards, right? Oh, yeah. I'm going to do.
Yeah. Meanwhile, maybe somebody in the government doesn't want futures markets to exist on whether or not Joe Biden is going to be the nominee of the Democrat Party in 2024.
I didn't say that.
I did.
So all right. So there's all those countries, and then they just give them 6 months to wind it up. That is the thing that really strikes me as unbelievable.
Yeah, I think PredictIt in their papers basically says, look, it's one thing to tell us don't start any more contracts,
right?
But it's another thing to say unwind the ones that are out there with real money on the line. Once this issue became public, the market is all it's messed up right now because some people are just trying to get out because they think it's going to get shut down. And I don't think whatever those markets are showing right now, I think people would say it's not reliable. But that's these markets, I think, can sometimes be far more reliable predictors than traditional.
Than asking people, right?
Yeah.
Because the idea behind it is that your revealed preference is what you'll put money on, whereas you'll tell a pollster any darn thing, right? So I do look at those. I find them very interesting. I have no skin in the game, but we'll have to look at what the Fifth Circuit does about this because, put due process, put what the law says, this bait and switch. Thank you very much, Russ. We are out of time once again, but thank you for joining us.